And I guess everything is a little bit of a small world. First of all, welcome so much everybody for coming here. Dan and I have collaborated previously and our paths crossed because I got introduced to his CEO, Rob Pierce, who the firm actually Wrays started in Perth over 100 years ago, and had the opportunity to catch up with Rob when I was on a business trip to Perth. And if I look at the needs of our community and the people that we work with, IP is one of those things that does come up, and people are kind of like, well, what is it? I've got a patent, surely that protects me. Or, no, have you actually got proof of concept? Have a seat anywhere, Paul. So it's really, I guess, understanding what intellectual property is, whether that's patents, trademarks, copyrights, and a billion other things that Daniel knows about and I know nothing, like Jon Snow. But how many more days? Anyway. But it's something that you need to understand what it is. Is it a shield? Is it a sword? Dan will explain what those references mean, but most of all, it's something that you actually need to be thinking about now within your business, because it can be very costly if you don't think about it at all, and heaven forbid you thought you knew something and you went out and spent tens of thousands of dollars on the wrong thing. So anyway, without further ado, Dan Beck.
Right. So as I said, come in, you're welcome. It's an informal thing, so stop me, ask me questions if anything pops up. And the challenge for me is I know nothing about you guys. I don't know what level your understanding of intellectual property is, which level to pitch it. So if you have more complex questions, or if you want to scroll it back to something more basic, feel free to do so. So I don't know anything about where you're at. This is an initial question. Do any of you have any registered IP rights?
Yeah.
You do? You do? So that can be a trademark. It's the most common, especially in Australia. Or it could be a patent or a registered design. And there's a couple of other more obscure ones. But we'll go through what they are and what they mean. Okay. My mouse is too far away. Go back. So, what is IP? It's intangible property. That's a more common way to describe it these days. It is property, just like any other kind of property. You can transfer its ownership, just like you can transfer a title deed for a piece of land or a house. As long as you own it, you can sell it to someone. You can also rent it out to people, or in IP land, it's more often described as licensing. Hence, it's referred to as intellectual property. But it's intangible, it's abstract. It's not like a tangible thing like a piece of land or a house. Why bother protecting it? Well, if you don't, firstly, someone else will probably come along and take advantage of you, and I'll go into various ways that can happen along the way. But also, you can leverage it for your business. In the case of a patent, for example, it can be used to raise money for your business. It can be used to get credit because it's worth money. Just in the same way that if you own a house or a piece of land, that could be a tangible piece of collateral to borrow money against.
That's after it's been granted.
Of course.
Yeah.
Yeah. But not only just, actually, even prior to grant, patents have value. A lot of startup companies, particularly in Australia, because it's so expensive to prosecute a patent through to grant, and I'll go into that later, will file a provisional application and then go around using that as a bargaining chip to raise funds for their business. So it's worth money even if it's not granted. But obviously it's worth more if it is granted. But there are means of valuing IP, whether or not it's granted or registered. That's a quick summary. can enhance your ability to make the most of your business. I'm going to go into the different types briefly, just to give you an overview. These are the four main types in Australia of registered IP rights. A registered IP right is a thing where you apply to a government agency for that right. They assess it, and when they grant it, they give you a certificate which says this is yours, belongs to you, we've put it on our register, and it's recorded officially. So you often see this symbol here, the R with the circle around it. That means that it's a type of IP right that's registered in that way. It's the sort of thing you've got to apply for and get granted. And the types you have in Australia are patents, they're for inventions, trademarks, which are for brands or to cover your business reputation, essentially. Designs, which are for the form of things, not the way things work, like patents. And the more obscure one that not too many people know about is plant breeders' rights. So I don't know if any of you are involved in horticulture or agriculture, but if you are, then plant breeders' rights are very important and very lucrative if you can get them.
Could you tell us the difference?
Is that a patent?
It's a kind of patent for a plant breed, yes.
Could you tell us the difference between, well, what's different about design IP as opposed to patents? What's the, because I can see there'd be some overlap.
Well, yes, there's overlap. Yes, we'll come to that.
Yeah.
But in a nutshell, patents for the way it works and a design's for the way it looks.
Okay.
That's what it is. And then there's unregistered types, and these are the three main unregistered types of intellectual property in Australia. There's copyright, which is a common law right. You don't have to apply for it. You don't have to apply to the government for copyright. If you created something, if you're the author of that work, then you inherently have copyright. So that comes with pros and cons. One of the pros is you don't have to spend all the money to get the certificate. One of the cons is if you want to enforce it in a court of law because someone's ripped off something that you wrote, then you've got to first of all prove that you wrote it, and secondly you've got to pay all those court fees, and you've actually got to go to court to enforce it. So it's got pros and cons. It's good that it's automatic, that we all have it, but it's somewhat more difficult to threaten someone with copyright infringement. You can write them a letter saying, I know that you copied my writing here, please stop doing it. And they'll probably stop doing it if they actually realise that that's what they did, which is most often the case. But then to actually sue them and get some damages out of them, to get some money, you've got to take them to court, and that's expensive and it's difficult. So that's one of the main drawbacks of copyright. Copyright's all about creative works, so it covers music and anything that's authored, any written works, can cover to a certain extent other things like artistic works in the form of sculpture, paintings and so forth. And then we have trade secrets. I'm going to go straight to that probably because it's more commonly useful to you.
I have a quick question. So, even with registered IP, you still have to take it to court. You still have to foot the bill.
Yes, if you want to seek damages, generally speaking, yes. But it's a more powerful instrument to threaten people with. You have a registered right, a certificate that says this belongs to you. Pretty much put it in front of them and say, hey, this is mine. People will immediately step back. They know that they're in trouble. It's a lot more clear cut, generally speaking. They would then know that if they did go to court, that they'll probably get hit with the legal costs in a more clear cut way. So yeah, you're right. It's still very costly. The difference is with a registered right, there's more cost up front and perhaps less cost later on with enforcement. With copyright and and these sorts of things, there's zero cost up front and a hell of a lot of cost afterwards. So it's a balanced thing. It's a good question though. So who can think of what a commonly known trade secret might be? Not that the actual secret's known.
Coca-Cola recipe.
Exactly, classic. Coca-Cola is a classic trade secret. The 7 secret spices of KFC is a trade secret. And there are pros and cons to say, well, let's say you could get a patent for the 7 secret spices recipe. Why would you do that as opposed to getting a trade secret for it? We'll discuss that shortly. It's something to keep in mind because it might help you think about what the best approach is for you or whatever you're doing in your business. And then lastly, circuit layouts, which I suppose is sort of analogous to the plant breeders, right, in that it's the more obscure one that's only applicable to a very specific area of industry. It's essentially, you know, the way these circuit boards are designed to lay out components that are soldered into a printed circuit board.
That'd be a tough one though, I think. A tough one to protect because today
Circuit
you can
layouts?
Well, you can mostly get around any circuit
Yeah.
if you can do it a different way.
Yeah.
You get the same result.
It
I
is,
think.
you're right. It has all sorts of problems.
Yeah.
But I just put it there to illustrate that there are other more obscure kinds.
Yeah, okay.
You know. It's kind of like a design protection, but it protects the design of how you put the components on a board. It can have specific advantages because a certain design can allow, for example, the components to fit more closely together whilst making sure they're not damaged by heat that's put out by other components. So it does involve a certain amount of inventiveness, but it's specific to that field. Excuse me. So firstly, we'll discuss patents. Pretty much you can get a patent for any product or any process with some limitations. You can't get a patent for a mere idea, for a scientific discovery, for a law of nature, or for a pure algorithm. E equals MC squared, you know, incredible law of nature as it's turned out. You can't patent that. It's really just a scientific observation. If, however, you can take an algorithm like E equals MC squared and apply it to do something, and something which involves a device, let's say a nuclear reactor, which is both a device and a process, you'd be able to get a patent for that, not for the law of nature that sits behind it, but for the thing that it does that's useful in the field of economic endeavour. And it's got to satisfy certain rules, and the main tests that patent examiners apply to determine whether it should be granted a registered patent right or not. First of all, it's got to be new. So that's assessed by when you apply for your patent, you get what's called a priority date, and that's the day that you first apply for it with the patent office. Then when the examiner looks at whether or not it's new, they look at everything that's been published before that date. It's as simple as that. And if they find that what you're claiming in your patent application was published a day before even, just a day, on some internet website or in a journal article or a magazine or on a television program, they'll object to it and they say, well, it's not new. It was known before the priority date, even if it was a day before. So that's an important thing to think about. A lot of inventors shoot themselves in the foot because they're so excited about their invention, they want to get it out to the world. They might post something on Facebook or whatever about it the day before they actually make their application, and that invalidates the application. It's got to be new. It can't have been published before.
Just a question regarding that. So, is there such a thing as a grace period? I've heard about this 12-month grace
There are,
period.
but they're not universal. So, in Australia, there is a 12-month grace period for publications and an 18-month grace period for presentations made at conferences and learned societies, I think are the words that are used. So if it's an area of research and you go to a conference and you make a poster presentation about it, and then later on you apply for your patent application, as long as that poster presentation was not more than 18 months before the day that you applied for it, it'll be graced. So the office will say, okay, we'll give you the grace period, but that will still give you your patent.
But that's, as you said, so that's for Australia. If you're planning on patenting in the US
This
or
is the
Europe,
problem.
yeah.
It's not universal. So
No, first to file.
that's right.
Used to be
well,
first to invent, but it's first to file.
That's correct, and that's universal now. It's first to file across the world. So, excuse me. That's why it's important to file an application as early as you can. The US does have a kind of grace period of sorts. Europe has no grace period whatsoever. All of Europe, and a lot of other countries around the world have no grace period, and there's no harmonisation of those rules. They're different for every different country. So the best advice is don't publish it before you put your application in, because otherwise you might only end up with Australia, and that's not a very huge economy. So, there are other tests that are applied. The next most important one is whether or not it's inventive. So something can be new, but not inventive. Another word that's used by patent examiners is if it's not inventive, it's regarded as obvious in light of the prior art. So in light of what's been published before, the thing might be new, but it's not inventive, it's obvious. And you might wonder, well, what's an example of that? Like, how do you explain obviousness? It sounds very subjective. To a certain extent, I suppose it is. Many of these tests have an element of subjectiveness, but there are clearly laid down rules that are embedded in case law from court decisions over many, many years. Patent law is very old. It goes back to the 1600s in our particular common law history, 1600s in the UK. It goes back even further in other parts of the world. I think the first patent as we know it was granted for a process for making Murano glass in Venice. So the Venetians invented patents, the Italians. Anyway, an example of something that might be regarded as obvious is what's called a co-location of things that are known. It's like taking a couple of things that are already known and putting them together in an obvious way. So one example I can think of is, okay, think about a Swiss Army knife. It's got lots of little tools in it, and they're great. At a certain point in time, a Swiss Army knife was brand new. It was a new thing. But maybe the first Swiss Army knife was just a combination of a picnic knife and a corkscrew. A picnic knife which folds out is well known, published before, people take them to picnics. A little fold-out corkscrew, like a waiter's friend, that was also known, and people also take them to picnics so they can open their wine bottle. So, given the fact that both of these things were known and they're both used in the same setting and in the same context, it's kind of obvious to go and put the knife and the corkscrew together. It's just a co-location of known things. It's just an illustrative example I'm giving you to try to think about what this inventive sort of test is. Another example might be, think back to the early 90s, a lot of people had mobile phones, you know, those clunky Nokia ones with the buttons. And it's a small electronic device that fits in your pocket. And then they were also carrying around these other small electronic devices about this big to play their music on, called MP3 players. At some point in time, someone thought, I know, I'm going to put the MP3 player in the phone. It's probably an obvious thing to do because so many people were carrying both devices, because the phone has a CPU in it that can do all the jobs that the MP3 player does, because people are already sticking their headphones into their telephones, so it's pretty damn obvious. That's the kind of vibe of what this inventive test is. There's another kind of patent called an innovation patent in Australia. In other parts of the world, they're called utility models. In general terms, they're referred to as second-tier patents. To summarise, they're patents that are cheaper, quicker, and easier to get that don't last as long. So, Australian innovation patent, I think, has a term of like 10 years. I barely ever apply for them, so I might be wrong, could be 8. Anyway, they're a lot easier to get because essentially all you got to do with an innovation patent is prove that it's new and innovative. And the innovative step is a lower threshold for grant than the inventive step. And in practice, what it is, well, as long as it's new and it seems like it's innovative, we'll give it to you. But your monopoly doesn't last as long with those. And then there's a bunch of other obscure tests that would take me an hour to explain, like support and disclosure, that relate to this concept called patent bargain, where, okay, you're asking the government for a monopoly that lasts 20 years for your invention. What's the public going to get in return for that? This is what's called the patent bargain. Because this monopoly thing, it's a big deal. You can make a lot of money out of it. You can exclude everyone else from doing it for 20 years. In short, the patent bargain is, for me to give you this monopoly, this patent, you have to tell me everything about how the invention works, and you have to write all of that in your application so that it gets published when it's granted, so that after 20 years of monopoly, when that expires, any member of the public can read your patent application and they can reproduce what you've done and they can work the invention. That's the patent bargain. We'll give you a monopoly, but only if you tell us how it works. And that's how drugs go generic after their patents expire. It's the reason why anyone can make the drug once the monopoly's up. Yeah.
So, quick question in the innovation patent. Is there a jurisdiction there where if you apply for that here in Australia, you mentioned about the utility patent as well? Is that you can then have like a more of a global coverage for your innovation patent?
Yeah, it happens more centrally, and I'm about to discuss that. Okay. So essentially, you apply for this thing through an agency that's global, and then you go out to all the individual countries one at a time. But in short, yeah, there's a way you can do that.
Okay,
yeah.
Even with the low threshold?
Yes.
Okay.
But not all countries have the lower threshold thing. A lot of them do. US, China, Australia, and Europe have them. So that covers most of the major economies, but yeah, not all countries have them. So it's not universal. Oh yeah, sorry. I think I had one further thing is that it allows you to exploit your invention exclusively. This thing here is a one-wheeled motorcycle. It's like an adaptation of a Segway, I think. It's from a real patent application. I just put it there because I think it's like crazy, as if motorbikes weren't dangerous enough already. But
take off the trainer wheel.
But it illustrates how you can see,
I think that's a patent for a mobile organ donor.
There are some practical things out there. There's some patents for
Well, there's some cost savings with that. You've only got one wheel.
People do some silly things too to try and hoax the patent office. Like so a patent attorney firm in Melbourne once made an application where if you read the claims of the patent and construed them properly, essentially what they were claiming was a wheel. Like as if that's not been done before. It was beautifully written. It made you think it was something way more technical than a wheel. So it was just thrown in there to try and confuse the patent examiners. I've already talked about that. There you go. It's up to 8 years. Because I'm a chemist, I don't do many of these, if ever, But people who prosecute patent applications in the mechanical and engineering areas actually do a lot of those.
Question, so then would you expect also a lot of algorithmic tech patents to be innovation as opposed to standard? Because as you said,
Yeah.
it's really hard to, you know.
Absolutely. Like, you know, apps and stuff, for sure. Software patents in Australia,
Maybe fall into that,
they
yeah.
often end up in this zone because they're easier to get. So here's some examples of the words. I was sort of going into this a moment ago when I talked about the wheel patent. At the end of, so the start of the patent tells you all about how the thing works. That's the patent bargain bit I was talking about. At the end of it, there's a thing called the claims, and the claims define the monopoly, which you're then granted, and which is used to assess whether someone's infringing your thing. So the words used are very patent attorney, and they're very legalese, and they're very difficult and boring to read. So you get all this sort of like configured to. So yeah, this is a claim for the preamble to a claim for an Apple Watch, right? A wearable device comprising a user interface component having an active state and an inactive state, a motion sensor, first processor configured to, and it'll go on and on for about a page, like describing all the little technical features of what makes this thing work. And the trick is that the patent attorney here is trying to draft these words so that they cover what's been invented, but also so that they make the scope of the monopoly as broad as possible, so that it's not easy for some potential competitor to come along and just make a minor tweak and get around your monopoly. And that's a real art. It's not an easy thing to do. The tension is to try to get the monopoly as broad as possible without making it so broad that it's invalid because it's not novel anymore. It's been done before. You know, that's the difficulty. And this one here is for this device called a scrubber, which is like a small, lightweight camping washing machine for clothes. And so you end up with strange kind of phrasing and words like a frictional washing surface. Yeah, I don't know, the words, don't worry too much about the words of claims, leave those up to your patent attorney. They're horrible things to read. You know, this table here might be described as an apparatus having a horizontally disposed surface with an orthogonally disposed column configured to support said horizontally disposed surface. You know, that kind of language, because they're trying to get this really broad monopoly. They won't talk about the shape of the table, because you could make that a hexagon instead of a circle, right? They won't talk about the colour of the table. If you said it was red in your claims, someone else could come along and copy your table and make it black, and they wouldn't be infringing. Those are the difficulties, and that's why the words in them are so horrible. So this is the patent system, and this goes to your question before somewhat about internationalisation. It's trying to summarise what the process is. The first thing you do is file your provisional. That gets your priority date, the date against which the prior art's assessed. You can do that at any patent office pretty much in the world under this thing that's called the PCT, which is the Patent Cooperation Treaty. The Patent Cooperation Treaty is administered by the World Patent Office, which is in Geneva in Switzerland. It's referred to as the WIPO, the World Intellectual Property Office. In Australia we just call it WIPO, but I think the Swiss don't like it when we call it WIPO because it sounds disrespectful. But anyway, WIPO administers the PCT. So what you can do here is you file your provisional with the Australian Patent Office, and it stays secret for a maximum of 12 months. You can choose to publish it at any point, out to a maximum of 12 months. If you don't bring it up from being secret within the 12-month period, it will die and no one will ever know about it. It will stay secret. So you can then elect to go into the PCT phase. At this point, the provisional gets published and forwarded to WIPO. So essentially, there's more complexities, but I could bore you with them. At this point, there is a choice. So you could have done this at 1 month after filing, or 2, or 3, or 4, but you've got to do it before 12. If you don't do it before 12, the whole thing just disappears. If you're not ready to go public and go WIPO stage here, but it's about to die, you can just refile this provisional again, and it starts the clock again. It'll bring your priority date forward to whenever you refiled it. What some people do as a strategy, they keep refiling provisionals for years and years and years because they don't want to go public yet.
Does the prior art become an issue then?
Of course, it means that the later you do it, that the more prior art is available.
Does your own prior art become
Well, this isn't published yet, so as long as you're smart and you haven't pre-published your own stuff, then you're fine.
Right.
But meanwhile, while you're sitting around waiting to go public with this thing, someone else might have published something that destroys you. So it's a dangerous thing to do. So the normal course of events.
Is there a difference between refile and just an update? Like if I'm just updating my provisionals, does it keep my filing date? And then
It can, yes. Obviously you understand quite a bit about the patent system. So you can also like file a subsequent provisional that just adds more data because you didn't have that data available when you made the first filing. And under those circumstances, normally it allows you to keep your original priority date, yes. And sometimes there might be a chain of half a dozen provisionals filed throughout this 12-month period, just adding more data and updating things. It's possible.
Adding new subject matter?
No, that's not allowable. Adding more data. So your original filing, if it's drafted well by a smart attorney, will be really broad. And it'll say, okay, this invention, it's about lots of ways in which to keep water out of the roof of your house. And you've got like 1 or 2 ways of doing that are already in there in your original filing, and it might be about a polymer skin that you paint on the outside of the roof and it stops the leaks. But 6 months in, you guys in the lab have developed some more better polymers, you know, and they do a better job and they last longer and they've got more resistance, and so you can start adding these additional polymers. As long as the original one was drafted to say, well, we've got these great polymers that keep water out of your roof, then it's not new matter, is it?
Correct.
It's just, so yeah, new matter's a tricky thing, and it just depends on the case.
So if you went, say you're going through the prosecution process and you've got to say rejection, 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 and you're at that point, and you then have some new subject matter. How you look at that subject matter is it new, completely new and unrelated to what you're doing? Would the examiner go back to the original specification and see that it's written in such a way that could introduce that idea? So at say your summary or somewhere in the body of the specification, it's...
Well, they have to. Every time you file something new, the examiner has to go back to the first filing and make an assessment of whether it constitutes new matter or not. If the attorney's drafted it real well, then they'll allow it. But, you know,
It's like a morph. You've been theoretically, you invented a system, a patent. You've got it. So over time, you haven't commercialised it, but over time you've morphed it a little bit, but it falls within this original specification you think it does, and the examiner's saying it hasn't.
There's no straight answer to this, so I don't want to labour on it. There's no straight answer to this issue.
Well, that's my issue as well.
I don't want to labour on it too much, but the fact is you can file new matter and you can do it at any stage throughout the whole process, but if it's deemed new matter, it'll be given a priority date if that is the date that you filed it, right?
Right.
So you can do it, but if it really is something new, if it really is an inventive improvement on what you originally filed, it's then regarded as essentially what is a whole new patent application with a new priority date. So, you know, it's complicated and it's a grey area, but I can talk to you about specifics if you require advice on that matter. I can't stand here and generalise about that
Oh, no, that's
without
fine.
lecturing for an hour and boring
Yeah.
everyone, you know what I mean?
Oh, no, I'm
But
just
if
being
you got,
greedy.
If you got specific questions, talk to me later. So after that, when you do this WIPO thing, World Patent Office goes through this examination process where they search the prior art, they report on your application, they tell you whether it's novel or not. You go through some iterations with an examiner, and after 16 months of this international phase, as it's called, under the Patent Cooperation Treaty, you then decide which countries you want to go for. And then you go file this thing in those countries. There's no true world patent, there's just this world patent system that allows you to get an initial exam internationally and then deploy the thing within each jurisdiction. So at this point, you've got to decide which economies you want to go for. This is the really expensive part right here.
Hit Japan.
Right, it's really expensive, right? What a lot of startups in Australia do, and researchers do this too, universities do this, they've got a great idea and they go right up to this point, and then just before they do this, they go and sell the thing to a multinational drug company, say in the US, the patent. They go, here you go, run with it. Or they'll license it. They'll say, you can rent this thing from me, you can go and produce these pills, but you've got to give me 10% of every unit that you sell for the duration of the monopoly. That is a very sensible business model for a country like Australia, because as you're about to see, this part is incredibly expensive. A lot of people have made a lot of money doing it that way. Don't be too attached to your invention. So this is like a general summary of how much it costs. You know, your prov, generally you can get a prov, the initial filing for between $2,000 to $10,000 or $15,000, depending how complex and big it is. And provisional applications can be like 5 pages long, or they can be 1,000 pages long. So it depends on the complexity of the invention. This international phase bit is an additional cost, and then when you get to that thing that's called national phase entry, which is where you choose how many countries you want, that's where the costs really kick in. So depending how many countries you want to go for, that's why this error bar is here. It could be like anything from like 40 grand to $250,000 just to go global with a patent. Yep.
So just the previous slide, I noticed China wasn't there. Is there a reason?
No, it's nothing personal. I just might put every country on the slide.
How much does it usually cost to?
China is, it's not too expensive. It's not like Japan, which is one of the worst. I think, you know, it's probably in the order of 10 to 15K. Yeah. So yeah, all this slide's trying to say is it's really expensive if you want to get a patent globally, and often a good business model is to start licensing out somewhere around here instead of like burdening yourself with all that cost.
And this doesn't include the actual attorney's fees and all that, and all the service fees as well?
Pretty much, yeah. This estimate on this chart does, yeah.
Okay.
So you're looking at around $250,000 to go truly global with a patent. It's a lot of money, but it's a powerful instrument if you get it. So anyway, the take homes are, it's really expensive, it's really complicated, you've got to be strategic, don't pre-publish yourself, and it's jurisdiction specific. You've got to go for a separate one in every different country. Designs, as I've already said, it's about the way it looks, and I guess the key point there is it's a 10-year monopoly with a design. Here's some examples. So this outfit, Intax, this is like an aluminium scaffolding product. So these are the sorts of things you see in a design application. They have drawings. That's a 10 that Kathmandu has a registered design for. As I said, it's only about the way it looks. It's not about how it works. And as you tweak the appearance of a design, you might have to keep refiling it. And like all the other registrable rights, it's jurisdiction specific. So if you want to get it in other countries, you've got to file it in other countries. Here's an example of a Melbourne company, Keep Cup, had a registered design, which is this on the left, and Gloria Jeans started selling this thing. And they got in a lot of trouble over it because it pretty much infringes the design registration. And Gloria Jeans then pulled that product because they got threatened with damages and litigation by Keep Cup. So it's just an example of how it can be worth doing this sort of thing. That's a Melbourne company. Moving to trademarks. So trademarks seem to be the most common thing. I mean, pretty much if you've got a business, it's worth getting a trademark, but there's some key differences with it. First of all, it wouldn't make any sense if you had to apply for your trademark registration before it had been published, would it? So that thing about it being novel in light of the prior art, I mean, doesn't apply here. There's a bunch of different legal tests that apply to trademarks, but you can get them in two ways. You can get the registered one, or you can basically have like a common law trademark right just by using it. To put that another way, if you've been building a business around your business name, even though it's not registered as a trademark, if you've built up a reputation, if you're well known, and if you can prove a track record of use and having a successful business associated with that name, then no one can take it away from you, nor should they be able to. And then if someone else, you know, let's say you had like, you know, Ken's turbochargers or something as a mechanic, and you had a huge reputation in Melbourne, and everyone wanted Ken's turbochargers, but you'd never registered it, and then someone else decides, oh yeah, I'm going to take this guy for a ride here in Australia, I'm going to go and apply for that as a registered right because Ken hasn't done it. That wouldn't work in Australia. You would be able to then contact the trademark office and say, this guy's application needs to be struck off the register because here's all the evidence, it's my business, I've been doing it for 10 years, so how should he be able to have it? That's how it works here. It's not how it works everywhere.
So if that has happened, should you perhaps go to a patent lawyer or somebody to
In the first instance,
advise on
you
that?
don't really even have to in the first instance. I mean, yeah, I would always say
Would that be like a show, like I'm involved with an agricultural society who has run a show for a long time, and then someone has set up the exact same show, and they just went, oh, okay.
I'm only talking about registration. So
Yeah,
if
wasn't
someone,
registered.
so if someone, the other person applied for a registration
Yeah.
for that show name,
Yeah.
then all you'd need to do is write a letter to the trademark office saying, hey, what's going on here?
Yeah, okay.
We've
But
been
have
doing
they
this for
copied
But
years."
what
your
if
name,
they,
though?
yeah, what if they have registered it, you
It shouldn't.
perhaps, you know,
Well, first of all, if the trademark office had actually done its job in searching
they would have seen that
properly,
that's been,
they should have seen it and they wouldn't have registered
Okay.
it. But if it hasn't been registered yet, and you can see they've just applied for it,
yeah,
then all you need to do is write an office letter
Okay.
saying, what are these guys doing? Clearly this is our stuff. And then they won't register it.
Okay.
That's how it works.
Yeah.
If somehow it did end up being registered, you can oppose it. And that's when you would definitely need the advice of an
Yeah,
attorney then.
yeah.
And then launch an opposition, which is a hearing before the trademark office.
Okay.
It's pretty informal, it's not like a
Yeah.
law court. I used to be a patents hearing officer. It's a lot more relaxed
Yeah.
than
Would you have that right forever?
Sorry?
Would you have that right forever? Like you could oppose it at any time, or you'd have to do it right then?
You can pose it at any time, as long as you can prove that you've been
Yeah.
using it before
Well, you
they
might not be in
applied
a
for it,
financial position to
before
do
they-
it.
Yeah, yeah,
But that's good, yeah.
yeah.
yeah, yeah, okay.
But this is the situation here. It's useful for you to know that. It's not the situation everywhere. So, and I'll explain that in a second. You can have a trademark for all different sorts of things, you know, just word marks, names, signatures, You can even have what are called sensory marks, and these have popped up more recently. It can be like just a colour or a smell or a sound or a movement that's somehow associated with your brand, with your reputation. So, I mean, there's some obvious well-known ones there. There's a less well-known one there that's on every slide.
So with trademarks, what's the difference between a DM and an R? Are they the same? Like, are they trademarks? Like, the ones with the circle on the side?
If it's got the R, it's
Yeah.
actually registered.
Yeah. And DM's not yet.
It's against the law, in fact,
Yeah.
to put the R there unless it's registered.
Okay. And it's not against the law.
All TM is saying is that this is our brand mark. So it's more ambiguous. It's not actually saying whether it's registered or not. So the ones to look out for are the ones with the R on it, or if it says registered trademark, that means they've really got it. There's some more, there's a couple of word marks there that you know. This is one that relates to the colour of the packaging as well, essentially. Everyone knows Apple and...
How would you trademark colour?
Oh, we'll get into that in a moment. You've got to associate it with your business. That's how. There's some, you know...
No, what I mean
iconic
is there are
ones.
like, you know, on a standard 8-bit computer, there's 65 million colour combinations. So you could be like a few shades off, right?
Oh, well, yeah, I mean, that would cause difficulties when you're enforcing in court.
Exactly,
Right? But one example of that is Cadbury have the colour purple for chocolate. And there was some issues in the past around that because there was that brand Milka. There's not a Cadbury brand, and they had purple on their wrappers. It was a different kind of purple. You don't see that brand anymore, but there was a fight about that. So it does cause
Is that why
issues.
they're not around anymore?
Pretty
the
much.
colour. I knew that they made it a little bit lighter, but I did hear the fact that they were, Cadbury had sued a few different companies for using the exact same colour.
Yes,
But
that
you can
also.
still get it in
But
Europe.
even different shades, because their registration said essentially their registration said purple for chocolate. So, another example of that is, do you remember that pizza company called Eagle Boys?
Yeah.
They have a registration, it's a sensory mark, for a pink glow associated with pizzas. Because if you drive up to an Eagle Boys pizza shop at night, it glows pink. They have these amazing pink lights, you know. And so they have a protection for that. They're like, pink glow, that's our brand. Everyone knows if you go to a pizza shop that glows pink, it's Eagle Boys. And they've got that. So that's kind of how it works. If there's something distinctive you've got about your business branding, doesn't matter how subtle you might think it is, if it's distinctive, you can actually get protection for it.
I had a client who they trademarked the words yeah.
Advanced hair?
Yeah.
Yeah.
I did their social media, yeah. See? You know who they are.
Everyone
and
knows
they
it.
trademarked.
Yeah. And it's about whether or not you actually have got a track record of making that distinguishable to your business.
Yeah.
So often, you know, if it's a really subtle one like that, like yeah, or like pink for pizza, you've got to actually have a track record before you can get the registration. So you'll need to have spent some years associating your business reputation with that thing. But once you've done it, you might as well apply for it. If everyone knows, well, you might as well, so that no one can rip you off.
Would
You
have
know?
been expensive though, because they're a big international brand. They go a lot of different countries.
Yeah, to go
So
for a lot of
registering it
different
all in all those
countries, true.
countries, yeah.
But to get one in Australia is not particularly expensive.
Yeah.
If it's just one class mark, you can file a trademark yourself in Australia for around $400. You know, it's not heaps. If you're making lots of money out of that particular aspect of your reputation, it's worth doing. There's someone who's got a registration for the smell of beer for darts. I don't know how or why. Surely they're not making much money out of that. But there's things like the shape of the chocolate for Kit Kat. And there's like this kind of movement. That animation is a registered trademark, or has been. I don't know whether that brand particularly took off, but And you can get them for shapes too, and this is where that thing of overlap comes in. There was a question from the gentleman up the back around overlap between designs and patents earlier. Do you recognise this bottle? Anyone know the brand?
Like a Lipton or something?
It is a tea, yeah. It's a nice tea, it's Nest tea, yeah. So a Nestle iced tea product. And they've got that trademark for this bottle shape. If you look at this, you could also have a design for this bottle shape. You could also potentially, if there was some aspect of it that provided some kind of innovative advance, whether it's the grip that you get out of that or something, you could also look at, say, like a patent, it's an innovation patent for that. So you could actually go for all of the registered rights, bar plant breeders' designs and plant breeders' rights, for this kind of thing. And what do you think some of the pros and cons of that might be? Any thoughts? Can you recall what the term is for a design?
Picture pattern?
10 years, sorry.
Oh, I thought you were asking a question.
Yeah, the term, can you recall what the term is for a design? It's 10 years, right? What do you think the term is for a trademark?
Much longer.
Ever?
It's as long as you keep renewing it. Coca-Cola, they've had a trademark for that name for over 100 years because they just keep paying the renewal fees every 10 years. And so it's indefinite. You can have it for as long as you like. That's why Nestle, because they're pretty savvy, would have gone for a trademark for this instead of a design. The design's only going to get you 10 years and then anyone can rip it off. You know, the classic Coca-Cola bottle shape is trademarked like this too. So those are the sort of things you need to think about when you're thinking about what's the advantages of this type or that type. In general, if you can get a trademark for it, you're wise to do so. The same thing relates to choosing between, say, a patent and a trade secret that I alluded to before. So the term of a patent is 20 years max. So would you go for a patent for the secret recipe of Coca-Cola, do you think? So that everyone in the public can use it after 20 years? Or would you keep it a trade secret if possible? And then you can keep it for as long as you want, as long as you're confident that you can enforce that with your employees, as long as you're confident that no one's going to let the cat out of the bag. Well,
but if you keep it as a trade secret though, and someone figures it out, you can't do anything to that.
exactly. So, pros and cons, you know, it's, yeah, the trade secrets are great as long as you're confident. And companies like Coca-Cola will have a very strict way of doing that, you know, they'll have like probably 2 people in the whole multinational business that have access to a very secure safe within a safe within a safe with like 3 keys for each level and 3 different people having the keys. You know, like they'll be really careful about it, and you need to do that if you're going to rely on that. So, you know, ugly rubber shoes that you're all familiar with, they're trademarked. Those things are trademarked. They've got a patent on them. I remember looking at the patent about 15 years ago. No, it'd be more than 15 years old now. It's probably expired, which is why coffee pods are now generic. So that's why they have a trademark on them. You can do these things in parallel. You know, again, smart company, Nestle, they would have gone, right, we'll get the patent initially, and that'll be around the machine and the pod and the way the two work, but let's get a trademark while we're at it. Then at the end of all of this, when the patent expires, we've still got control over the shape of our pods. If anyone wants to use it, they'll have to license it from us. Yeah, and that's the key test. It's got to be capable of distinguishing to be eligible for trademark protection. You might be familiar with a particular aspect of trademarks where if something's really generic, you can't get the registration. So, like, what's an example of that? What if you had just like a region with a product like Barossa wines? You think you'd be able to get a trademark for it? Well, it's not capable of distinguishing. It's too generic, basically. You'd have to be more specific than that, because there's too many Barossa wines. Any questions about trademarks? One thing I wanted to touch on too was that this point relates to the point that I made about the fact that you can get common law trademark just through having used something. That's not global. It doesn't apply in every country. So, are you familiar with domain name squatting? And people can well, in China, we have a thing called trademark squatting, because in China they don't have that principle of prior use embedded in their law. The Chinese trademark system is a first to file system. So there are people in China whose whole business is actually centered around going on holidays overseas to wealthy Western countries and taking lots of photos of new brands that they've never seen before on the shelves. And then they'll go home to China and then they'll apply for all those trademarks in China.
Such a joke.
Because then they get to be in control of them. And so then when all of a sudden the Western business decides to look to expand globally and they want to start importing their product into China, and then they go to the trademark office and they say, right, I'd like to get a registration for my mark. And the Chinese trademark office will come back and say, I'm sorry, but your brand's already registered here. And so then the only way for the business to get it is to contact the owner of their own brand and buy it off them. So that's trademark squatting.
I had that happen to me with my website name.
Yeah, right.
Yeah,
with domain name squatting.
Yeah, with my I had to buy it off someone, and I didn't look at the email properly anyway, and I bought it off a fraud.
Yeah.
And then I paid like a couple of $100 by fraud. And when I looked at the email again, I'm usually really good with this stuff, and then I looked at the countries that they were operating in, I'm like, great.
Yeah.
You got done.
Yep.
Yeah, and I found out it's because like they can even, like for example, say you start looking at your name or you start looking at names, like there's people in the back end that can see what you've searched.
Right.
So I've always told my friends, like, unless you know you want to buy that day, do not search the name that you want, otherwise they can buy it off you then try and sell it to you for a much higher price.
Yeah. Google.
And you want it, so you're going to buy it.
Google can be your best friend.
Do you
your
want
worst enemy.
That's the question you've got to ask
Yeah.
yourself. Do you want that one? Just make up a new one.
Yeah. Oh, well, it's the business name that you came up with, or the name that you come up with for your
But was
business.
your product commercialised?
Oh, well, it was, not
That's
yet,
quite a
but-
common scam that's going on at the moment.
Yeah.
I nearly fell prey to the exact same scam myself, because I'm on the board of a museum in Bendigo that's like recently changed its name from Golden Dragon Museum to National Chinese Museum of Australia, and so we wanted to get NCMA, .com.au as a domain name, and I went and did the ASIC domain name searches and found that it wasn't occupied, and then like a day later I got this scam email saying you've got to buy this domain name, and it's just because I googled it. That it happens. You've got to be careful.
Isn't it like when your business name comes up, because that's just happened to me, and I got 2 letters in the mail saying, your business name's come up, pay for 3 years, $200. But then I actually went to the ACO, whatever it is, and I go, it's only $4 for 3 years.
Exactly.
So they've added
Yeah.
more than double.
Don't believe
Yeah, I
them.
know, but the way the letter
Yeah.
is.
Yeah. Yeah, I know. You've got to read this in very carefully. And don't believe it. When people are demanding money from you, always read it critically and don't take it at face value. Especially if you don't know from a bar of soap and they're just contacting you.
Oh.
But an example of this this trademark squatting in China, someone had squatted the trademark for iPad years ago. Massive. Like Apple didn't think that they might want to use iPad in China early enough, and in the end, Apple had to purchase the mark off the person who'd squatted it. I think they paid about $5 million US.
Oh, that's
To-
costly, isn't it?
Yeah.
Which is nothing for them.
Yeah,
Yeah.
but it's a
Yeah.
pain.
Right,
So
so
then-
that,
So that,
not even
in
a
short,
coffee money.
The take home is like, if you have the slightest inkling with any of your business activities that you may one day wish to expand into China, go and file a trademark for your brand straight away. Do it.
And then go.
It's not that expensive, you know, to do the filing. It's a lot more expensive to then have to go and buy it off a squatter. These things are changing. China is gradually modernising their IP system, but at the moment it's still a trap. So,
I think my favourite story for domain squatting is McDonald's.
Yeah.
Do you know the McDonald's story?
No, I
where
don't.
someone registered it and Macca's were offering to pay him, but he wasn't happy, and so they said, you know, they always tried to scare him, and so he made it a pornography website, which twisted their arm, because then the last thing McDonald's wanted is people Googling, especially families and kids,
yeah.
and then coming, so he really twisted their arms. That's the other, you know, they could really force you. No idea.
On that,
Undisclosed, but they can really. So let's say you're like, well, I'll change my name to Mac, the MAC or whatever.
yeah,
They can do that and force you
yeah.
to buy the domain.
And that's like, you think about it, it's so easy to do it with domains because of the back end stuff that's going on with your browser. It's a lot more difficult to do it with a trademark. You've got to, as I said before, I mean, I'm sure you can discover new brands online very quickly now, but in practice to date, what's been done is, you know, touring around with a camera to get to mine the really fresh ones. On that issue too, with patents, if you've got something that's an invention and you haven't applied for your provisional application yet, and you haven't published it, and it's secret, worst thing in the world that you can do, and they used to teach us this in the patent office, because we do prior art searching on provisional applications which were not yet published. Worst thing in the world you can do is go and search exactly your invention on Google. Because there's people in the background looking for what other people are doing. So we weren't allowed to search exact invention on Google browsers. We have other secure tools in the patent office for clandestinely searching inventions that are unable to be monitored in that way. But if you did have to go to Google and use Google, the advice was always just look for elements of the invention, bits and pieces of it, not the whole package at once.
That's
Don't-
money well
that's-
spent by getting somebody like you to do that search rather than using Google and then.
Absolutely,
Yeah,
but if you do
smart.
want to use Google to do some reconnaissance or that, and just be conscious that you could be disclosing what you're searching.
Even
So-
if it's in incognito mode or private,
Yeah,
same thing.
yeah, because Google will log it. Their business is centered around selling data. Who knows who they're going to sell your data to? So just be mindful of it and try and search smart. You can search smart. You can search just elements or aspects of pieces of the invention without looking for the whole thing at once.
But that wouldn't be a big cost to get that done by a professional.
Not if you're
Organiser.
serious about it as a business. Yeah, you can get a full prior art search
A big,
for in the order of $1,000
Yeah,
done.
money well
you know,
spent.
It's money well spent.
Yeah.
Yeah, and it'll be done by search experts who know what they're doing.
What about to trademark like your logo and your business name?
Trademarks aren't the same. If if you want to search registered trademarks, just Google Atmos, ATMOSS. You want to write that
But how
down?
much does it cost?
Nothing.
No, to register.
Oh, to register, sorry. Well, you can register your own thing. You just log onto the website at IP Australia. You can do it yourself. And it's around about $400 for one class. But when you register a trademark, you've got to specify a class. These things are called niche classes. And so, for example, I think class 42 is food and beverages. You know what I mean? So like at Eagle Boys one would have been the glow of pink for pizzas in the class 42 because it's food and beverages. It's what they sell. So you know you can have McDonald's would be in the food and beverages class as a mark. But if you search Atmos, that's IP Australia's website for all registered trademarks, and if you just search McDonald's, you probably get lots of hits. You get someone else who's registered McDonald's Mechanics Services because it's his surname and it's his business, you know. But it'd be a different class, nothing to do with food and beverages, so there'd be no confusion. Everyone knows that's not the fast food joint, it's a mechanic, but it's registered in a different class, and that's how come it was able to be registered.
Sometimes your class might not be clear, might
Well,
it?
this is the thing, and that's why I say that because of your question. You're charged per class.
Yeah.
So if it's not clear and you need to go for 3 or 4, and this happens with people who say run hospitality, where they might have accommodation and they've got like obviously food and beverages, they've got a restaurant, and then maybe they've got entertainment because they've got a bar where they do gigs and stuff. So suddenly you've got to have 3 classes and it's $400 a class. But it's all for the same name and the same logo, you know what I mean? So yeah, it can be pricey, but one mark, one class, about $400. If you want it to be bulletproof, you come to one of my colleagues who'll do it for you and make sure that it's really good, and it's more like $1,000 instead of $400. So, you know, that's the ballpark figure though.
Yeah, I did it with my business.
Yeah.
Do you have to trademark your logo and your name separately?
They would be, it'd be a word mark and then a composite mark. So the logo is called composite mark.
It's going to be 2 applications.
Yeah, they would. Yeah. This is just a quick graph of S&P 500 market value over the years. That's market capitalization of the top 500 US publicly listed companies. And it just shows basically that the value in intangible assets is growing, intangible assets is shrinking. I think it's probably also a reflection of, because these are American companies, how all the manufacturing is shifting to other parts of the world, and all the really massive American companies are outfits like Google and Uber and that now. Who rely heavily on intangible assets. But I think it illustrates why IP matters. And I've already talked about how it's tradable. It can be worth a hell of a lot of money. I'm going to start rushing through now because these are just like overall advice points on what's good to do in your business. You know, you can leverage it, you can sell it, you can build market perception. In a nutshell, it's just good if you can just start thinking about IP in relation to your business. That's all. If you've got a larger, more complex business, you might want to actually develop a strategy that aligns with your business strategy, and even write up some practices and procedures. But it's not always relevant to everyone. And why? Well, because it aligns with good corporate governance principles. Allows your board to manage risk and improve performance. You've got to be thinking about who creates it. It can be anyone in your business who's solving problems, basically. Anyone who's putting out product, generally they, one way or another, will be solving some sort of problem along the line. So you might not even occur to you that someone in your business is making IP. I.e., just think about it. It can also be contractors and external suppliers. You've got to be clear about who owns it, and it isn't always clear. For example, generally the legal common law principle is the person that creates it owns it, subject to some caveats. So if you've contracted some work out, then the contractor created the IP and it belongs to them. The classic case in point is that say you ask an architect to do some plans for a house for you, and you build the house, and this happened in Queensland relatively recently. A builder who's got a construction company got an architect to draw these beautiful plans for this amazing house, and they built the house. And the builder guy, he loved the place so much, thought it was fabulous. He went and took the plans, a copy of them, and built another one on another piece of land he had up the coast. Not realising he was actually using the architect's IP. You know? And he got sued for it massively. You've got to be careful. It's that same principle of like when you get a professional photographer to do your wedding photos, the photographer always says to you, the negatives are mine. Not that anyone uses negatives anymore, but the photographer created the thing, even though you're contracting out and paying them. They get to have the IP, and they can reproduce those photos of your wedding and use them for their promotional purposes or their advertising, and that's the way it works. So be aware of that.
The architect story, he probably knew that the guy was going to copy his wedding until he built the house.
Possibly,
Yeah.
possibly. Would have helped him become famous.
He must have been
as well.
rich too,
So can
otherwise he
they,
wouldn't
like,
have
in that sense, can they use the photos of you even without
Usually.
your permission to reuse
Usually.
your image, your personal image?
Usually, yes.
Okay.
That's how copyright works. So, you know, it's normally, you know, professional operators in this country will put a form in front of you that you sign that actually clearly states that, and they won't do the photos for you until you sign. But even without such a form, the rights in the photographs would default to them because they're the photographers, so they'd be within their rights to use them.
And they've got to be careful though how they use them.
Absolutely.
Yeah,
They
because
can't
then
be
your rights come out.
They can't be.
Well, that's
They
right.
can't
Yeah.
be defamatory or anything like
Yeah,
that. Yes,
I mean-
that's right. But yeah,
It's a two-way street.
yeah. A classic case of.
That's right, you can go ahead.
No.
Oh, what I was going to ask was, it's very unclear. So let's say you work for a very innovative tech company,
Yeah.
and you sign a contract, and
Yeah.
they own any IP, while you're working there.
Yeah.
And then you move to a very similar tech company as well.
Yeah.
And then you develop something that's sort of related.
Yeah.
So how does that work? So does this company then have the rights to sue the other tech company, or?
Maybe, because it's a very general question
Yeah.
you've got, but maybe not. The other general rule is if the company's paying you and you're developing the IP in the normal course of your work, that's what the case law says. So in other words, if it's the job that the company's actually paying you to do, if you're doing it during paid hours, if you're doing it in the company's residence and its property, if you're doing it using the company's resources, equipment, computers, that's the normal course of your work. So if you generate IP under those circumstances, the IP belongs to the company in this country for the most part. Things get grey where it's not so easy to define what is the normal course of your work. These days you've got flexible working arrangements, people work at home, they have a laptop, they just take it from wherever they go. It's getting harder and harder to actually pin down what's the normal course of the person's work.
And I think, yeah, it's down to sometimes just one word in the contract, while versus during, for example.
Yeah.
Absolutely, and
Yeah.
probably what you should know, I mean, there's a touch of cynicism in what I say here, but it's true. A lot of the contracts, the intellectual property contracts that your employer makes you sign, a lot of clauses in them, a lot of times, wouldn't stand up in a court of law if you could be bothered paying the money to fight them.
Interesting.
from another perspective, to put another spin on that, if you're an employer and you're making your employees sign these contracts, I would encourage and urge you to continue to do so. So, why is he saying this? He said they're not worth the paper they're written on. Well, the fact of the matter is, 99% of people, having been presented with a contract like that and signed it, won't question it. And they will never pick up a fight because they go, okay, I signed the contract, I'm not going to argue, it's your IP. So it settles things 99% of the time and keeps things clean. So use those contracts if you've got a business. But they really aren't as solid as you might think a lot of times. It's just that they work on 99% of people. So they're a good threat. Is that clear? Yep. Ensuring clean ownership. So we talked about that now, written provisions. Do use them, because the way we're framed here in perhaps less cynical terms is they help avoid costly legal discussions down the track. It's kind of just what I said. Most people won't argue them, but you know, like if you didn't have that contract, you suddenly get at least an increase of tenfold of people demanding that it's their IP and not yours.
Can't let blood get in the water.
Exactly. So yeah, I mean, again, think about IP. Some larger, more complex operations might wish to actually conduct an IP audit. It won't help with IP that's already walked out the door though, but consider who owns IP, what different types of IP you've got, review your practices and procedures. Basically, think about it again, actively identify it. If someone's doing this process up here, there's a problem, they're developing a solution to it, they've probably developed IP, your business. Basically, try to get employees and or yourself, if that's your context, constantly thinking about these things, because it's surprising how often people only come to guys like me when something's gone wrong. Because if you'd actually been thinking about it beforehand, nothing would have gone wrong. So, again, as I said, think about it. This is an interesting one. You know, actively identify and record it. This is a pretty normal-looking project development schedule with a Gantt chart. There's no reason why you couldn't have points at which you identify, you know, do we have an intangible asset yet? Project development plan. Adopt good IP practices, which pretty much means record it. There's this thing called a disclosure document. Record it and keep a database of the IP that you've got in your business. Keep records. If you've got the record, it's easy to prove that you own it. It's easy to prove when it was developed, who developed it. If you don't have the records, you've got nothing. It's just he said, she said. And use defensive protection measures. There are all kinds of defensive protection measures, as in management of publications and disclosures. Let's say you've got a competitor and you want to avoid them. You want to avoid them applying for a patent for something that you know they're working on. Well, if you want to be nasty about it, you could file a patent application for what you know they're working on and then publish it straight away. You know, even though you might know that it'll never get granted because it's not valid, because it's not the paper it's written on, once it's published, your competitor can't get a patent, can they? Because you just went and published it. There are all sorts of offensive and defensive approaches to this. And unless you've thought about how they might work, well, you'll never think about them as a strategy. That goes to what I was just saying there, understand the IP landscape. Know what your competitors and customers are doing and try and use it to your advantage. I mean, do you guys know who your main competitors are in your operations? Have you thought about it?
Don't build a market.
Something else to consider about that is that your worst enemy could be your best friend.
What's
And
that?
often that's not considered in this space. Someone who's a key competitor of yours could in the future be a really worthwhile person for you to license your patent to, because you're working in the same space and you've got a genuinely good idea. So this is essentially summarising what managing IP well looks like. The upshot being you get growth in revenue, you reduce operational costs, and you increase your market share. And this is what managing IP poorly looks like. You waste time, effort, and money. You miss enforcement opportunities, which are opportunities to get money. People run off with your ideas. And this is what failing to manage IP completely looks like. And this is often when I see new clients come in the door, when something's just completely gone wrong, most often. And then you're looking at this kind of thing. So you remember this cuts both ways. Okay, so you might have a great idea and you might want to get a patent for it, and we've talked about that. But also, what if you're not interested in a patent and it might not be relevant to your business model? Have you at least checked whether someone else has got a patent for what you're about to do? Because if you haven't done that, you might be up for an infringement lawsuit. If someone else has got a monopoly on
Well,
it.
that goes back to what you said earlier. Get a search done.
Exactly.
I mean, that's the money well spent right there.
It's called a freedom to operate search. Yeah.
Wow. That normally comes out at the end, but the searching to see whether what prior art's out there without giving up the bank on Google.
Oh, yeah.
That's really good money spent.
Well, I think of it as prior art is when you're looking to apply for a monopoly. But whether you've got a monopoly already or whether you're not interested in applying for a monopoly, but you just want to do something, freedom to operate search is that. It's just, is anyone else going to sue me if I do this type search?
It's always good fun to have an argument over money.
Yeah, exactly. Yeah.
You know, I go for it.
So, we give these things to universities, basically, and universities fill these things out. Whenever their researchers develop some new innovation or IP, on that day they'll fill out a form like this, they'll give a reference number, they'll give it a name, write the details of what the innovation is, and so on, and then that's a piece of paper that gets locked up in a safe, but it records who did what when. And it's really useful later on for helping with all sorts of things, like if Joe Blogg's just left the lab in a disgruntled fashion and he's gone off to some other university, and then a year later suddenly this other university looks like they're filing a patent for this thing that's lying in your safe that says it belongs to you. You know what I mean? And once you've collated a whole bunch of those kind of forms, you keep a register. So it's pretty much a spreadsheet. I've referred to it as a relational database here, like that, with its reference number and the date and its title. That's what universities do. A lot of large companies do it too. It's just, the idea is just to get you thinking about how you can manage records, that's all. And there are a lot of different tools that can help you with that, including protection option flow sheets, which are something that I really enjoy, which would describe, okay, what's the best approach to protecting the idea I've got. So like that's form completed. Does it have commercial value? Yes. Okay. Can it be reverse engineered or otherwise easily determined by a competitor or third party? No. If it can't be reverse engineered, such as the recipe for Coke, then can details of the invention be kept confidential? Yes. Well, go for the trade secret option. You know. But if, on the other hand, it can be reverse engineered really easily. All someone needs to do is buy one, take it apart, and they can build it. Then you probably want to go down looking at the path of getting a patent, you know, or if it's not patentable and ideally able to be enforced, then you might want to just defensively publish the invention. You publish the details in the appropriate manner, and then at least no one else can try and go and get a monopoly on it somehow. So there's all sorts of decision making that you can do to decide, well, what's the best way to protect this thing that I've got. And this just summarises some of the simplest ones.
I didn't hear what you just said. That's all.
Sorry, there's all sorts of decisions you can make as to what's the best way to protect this thing that I've got.
Oh, it's important.
Yeah.
Very, very important.
And there's so many different options. It could be registered IP, it could be unregistered IP. It could be neither, but just making sure no one else can get either as well by publishing it. You know, all sorts of different ways. It's complicated. And pretty much that's all I wanted to say to you, was that it's complex. You probably need some advice on specifics. You can get that from someone like me for free for a 30-minute consultation. You can work it too. I mean, there's an outfit called IPTA, the Institute of Patent and Trademark Attorneys in Melbourne, that lists all the registered IP attorneys in Melbourne. You know, you can come along and get a 30-minute free consultation off me about your idea, and then, you know, get a bit more savvy after what I've said, and then go and look up some other guy at some other business and get another 30-minute consultation out of him, and do the rounds and get half a dozen of those, and by the end of it you might have a really much clearer picture about what the right thing to do is.
Or you might be more confused.
Well, you might be, but probably not. Because you know, most of the people here, I think, are probably pretty fast learners.
Yep.
So that's all. Thank you.
Very
And
good.
thank you for staying on for the extra time. I think we went
Thank you.
half an hour over. Any more questions? Yeah.
I'm just, I'm not sure what everyone else is here for, but out of curiosity, so when